will introduce today's speaker. Anne?
Thank you so much, Barbara. I really appreciate it. And I have to say, it is a huge honor to be able to introduce LaDoris Cordell, who is more than a giant in the legal community, but also in the social justice community. And you will all see she's an amazing speaker as well. She's had a storied and very impressive career. After graduating from Stanford Law School, she opened her own law office in East Palo Alto in 1978, and then was assistant dean for student affairs at Stanford Law School. She was appointed to the municipal court in Santa Clara County by Governor Jerry Brown in 1982, and then won an election to the Superior Court of Santa Clara County, making her the first African-American woman to be on any Superior Court in Northern California. She was on the court until 2001, which was a great loss to justice in our community, but she then started working as a vice provost at Stanford, and then she ran for city council in Palo Alto and was had a 4-year term on the city council in Palo Alto. And in 2010, she became what a lot of people know about her, which was she was selected as the independent police auditor in San Jose, and had an amazing run there where she made a big difference in the fairness of the police department until 2015. And she has received an untold number of awards for community involvement and for her judicial career. And she has recently written a book, which I think will be available to people here. And it has received unbelievable accolades for it's about her careers in justice. So you have a great speaker coming up, and very appropriate for the League of Women Voters.
Well, thank you, Anne, for being my friend and for that lovely introduction. I want to congratulate Eileen again. She was surprised by the award, but from what I heard, so well deserving. And I thank the West Valley League of Women Voters for inviting me to participate. The League of Women Voters, you stand for democracy. And right now, our democracy is at a major test. So thank you for inviting me. I'm not going to speak to you for a long period of time, and I hope that we can get good questions in the chat room. So I'm just going to launch in and start talking to you all. In June 2019, I began writing Her Honor about my nearly 2 decades on the bench here in Santa Clara County. It's part primer about the world of state court trial judges and part memoir about my nearly 20 years on the bench. So part primer, part memoir. I call it a new genre. I call it a primoir. Can you move the next slide? The one and only silver lining for me about the pandemic was that it forced me to stay home and to write. But there would have been no book but for my parents, who saved the letters that I wrote to them about my cases. Next slide. These are my parents, neither of whom sadly are with us anymore. But what I did was every Friday for the last 8 years that I was on the bench, and I think I did this because my parents loved to hear what I was doing in the court each day. And so I decided to write letters. And when I say letters, I don't mean emails. I'm not talking tweets. I'm talking real letters that go in envelopes with postage stamps. So I wrote them letters every Friday. And why Friday? Because generally in the afternoon, trial judges don't have hearings because we're preparing for the next week. And I wrote about everything that happened that week, including the names of people, the names of cases, the decisions I made. And I also wrote about how I felt about them because these were going to my parents. I didn't make any copies of these letters and I sent them off. Well, when I retired, I took a visit back home, back to the East Coast, just outside of Philadelphia. And during my visit, my mother said to me, "What do you want me to do with these?" And she pulled this box out of a middle room closet. My mother was a very organized person, thank God. And she had saved every one of my letters, 8 years worth of letters. So I said, wow, I'll take them. So I packed them up and sent them back here to California. And it took me about 3 years before I could start to read the letters. And when I did, I was surprised by how many cases I had presided over. I was surprised by the variety. It just reminded me of the variety of cases. And that's when I thought about the possibility of writing a book. So without those letters, I would never have recalled the stories that are in the book. I have many war stories in there. And this is some of what I wrote about my parents. And this is from chapter 1, Bitten by the Judge Bug. Lewis and Clara Hazzard had worked hard to provide for us and to ensure that my 2 sisters and I went to college. Their mothers had been the help, domestic workers who toiled for next to nothing, serving wealthy white families who resided in Philadelphia's prestigious mainline suburbs. When my mother, a high school graduate, and my father, a graduate of North Carolina Agricultural and Technical College, married in 1943, they had neither an inheritance nor a nest egg to get them started. What they did inherit, though, was a terrific work ethic and a powerful drive to succeed. My parents would come to own a home and operate Spring Cleaners, a dry cleaning business that supported our family for 40 years. I completed the book in July 2020, and it was published a few months later in October 2020. Next slide. As Anne noted, I was appointed to the bench in 1982 by then Governor Jerry Brown, making me the first African-American female judge in all of Northern California. And in this slide, you can see my parents, my then spouse, and my 2 daughters, Star on the right, the little one, and Sharon, and they are now in their 40s. Sharon is herself a lawyer. Next slide. With this appointment, I set out to mete out justice, as I note in the first chapter, untrained, untutored, and unnerved. And giving me the oath and swearing me into office in 1982 was the Honorable Felton Henderson, who went on to the federal bench and continued to be a friend and mentor throughout all of my years and up to today. Next slide. The world, and it's blank for a reason because I want you all to focus on me for a minute. The world of a trial judge is one big drama, which is why the fact that I majored in theater in college was just the best preparation I could have for being first a litigator, because there my audience is the jury to persuade, and even better preparation for a judgeship, where in the courtroom, I'm the producer director. Anything goes in a courtroom. And let me tell you, people lose their inhibitions and then, well, hold on to your hats. So in her honor, there are lots of war stories from the variety of cases over which I presided. In a chapter about probate court called Where There's a Will, I tell the story about a wealthy inventor, a Stanford Business School graduate, who left his entire estate to Tom, Dick, Mary, and Kim. You show the next slide. 4 feral cats. You show the next slide. Okay, there we go. Next one up. Nope. There you go. I kid you not. Tom, Dick, Mary, and Kim. And this is from the book, from the chapter Where There's a Will. The Walton Trust provided that $600,000 was to be used to maintain the cats, quote, in a most pleasant manner and pleasing atmosphere that as I have been accustomed to give them during my lifetime. And I thought, what lawyer came up with that wording? So the trust also bequeathed $3 million of real estate to 7 animal charities. The 3 lawyers who represented the 7 animal charities contended that the trustee had improperly used the trust assets to pad his pockets. Preferring mediation to litigation, I spent several hours in discussions with the attorneys and worked out a settlement. But most important, I ordered that Tom, Dick, Mary, and Kim should continue to live in the comfort and care to which they had grown accustomed. Next slide. So I have a chapter in the book called Bad Judges, where I profile some really bad actors in Black robes. And yes, I included myself in that chapter because some cartoons that I had drawn did not sit well with a few of my Black-robed colleagues. So these cartoons that I had drawn, I donated to Legal Advocates for Children and Youth, LACY, a nonprofit. And LACY then published the cartoons in calendars and then sold them to raise money to provide legal representation to young children. So again, this is from the book, the chapter Bad Judges. The drawings depicted judges, lawyers, jurors, and me in humorous situations that illustrated common legal terms. In the first 3 months of 1999, calendar sales generated more than $9,000 for LACY. In June, I received a letter from the Commission on Judicial Performance informing me that an anonymous complaint had been filed against me, alleging that my cartoons, and I quote, impugn the integrity, impartiality, diligence, sobriety, and competency of the judges depicted, potentially eroding public confidence and respect. Well, never mind the long and revered tradition of parody and satire of our legal system by such famous cartoonists as Charles Bragg and in France, Daumier, and never mind the protections in this country of the First Amendment. So here's what all the fuss was about. Let me show the next slide. All right, so this is what got me in the category of being a bad judge. I drew this cartoon, and once you take a close look at it, and it's a kind of, I just drew a generic judge, bald white guy in a robe, and he's holding, as you can see, a bottle of Johnny Walker Red, and behind him on the back of the calendar is a calendar, and each day has golf written on it until you get to the last week, and there's a line through it, and that's retirement. And then the days after that, the next 3 are golf. All right. So the purpose of the cartoon is to depict a common legal term. So you're supposed to look at it and say, now, what is that? So I'm going to tell you what this one is. This is take the fifth. Get it? Take the fifth. Sure. Okay. So that's what got me in trouble. So let me just show you another one. Again, got me in trouble. So we go to the next one and see if you can guess the legal term. All right. So that looks kind of like Newt Gingrich, right? Okay. In a courtroom, and he's looking at something, right? And that is a cross. So a legal term, cross-examination. All right? Cross-examination. Okay, now you get it. Let's do one more. Okay, so I'm at the bench, and I have people in the courtroom, and they're doing all weird kinds of things. You can see my arms are out, I'm waving them. Other people are doing things with their hands and moving around. What's the legal term? It is make a motion. Oh, okay. All right. So, so I was investigated by the Commission on Judicial Performance. This is the body that disciplines judges and has the power to remove judges. And so what happened to me? Well, I'm going to let that be a little teaser for those of you who haven't read the book. And let's just say it isn't what you think. All right, so I'm going to go on now to the next one, which is just to focus, a blank slide. It's going to focus on me, I hope. Next one. Okay, because there are more than 15 different topics in my book, I've chosen to talk to you, West Valley League of Women Voters, about 3 topics that I think will particularly be of interest to you all: juries, judicial elections, and judicial independence. All right, we'll start with juries. The right to a jury trial is enshrined in 3 places in the United States Constitution. Article 3, the 6th Amendment, speedy trial in criminal cases, which is mandatory for all of the states, and the 7th Amendment, which is jury trials for civil trials. And that's optional for the states, but all the states have opted in and have jury trials in civil cases. Next slide. I loved jury trials because I'm a people person. And I saw these trials as ways to introduce people to our legal system in the hope that jurors would have a good experience and feel good about our legal system. Next slide. Jury selection, I found fascinating, amusing, and annoying when people who saw jury service akin to the plague did their best to get out of jury duty. And I hope, because I can't see hands raised of everybody, I hope that many of you have actually served on a jury. I haven't, and I would love to be able to do that. And it is my hope that those of you who have served on a jury found it to be a positive experience. However, I can understand why many avoid jury duty like the plague. There's the time just wasted sitting around for hours, not knowing what's going on. And there's the compensation or lack thereof. And this is from a chapter in the book about juries that I call Thank You for Your Service. It doesn't help that compensation for each day of jury duty, the time waiting in the jury room, during jury selection and actual jury service is a pittance. Juror fees range from a high of $50 per day, Arkansas, North and South Dakota, and federal trials, to $5 a day, New Jersey and Kentucky, to nothing, Delaware and South Carolina, and everything in between. New Mexico, which ties its juror compensation to the state's minimum wage, pays jurors $7.50 per hour of service. California is near the bottom, coming in at just $15 per day. When full-time employees are called for jury duty, only 8 states and the District of Columbia, and that does not include California, by the way, require employers to pay their regular wages during jury service. I have a chapter in the book called The Fix, and it's in the next to last chapter, where I propose fixes to many of the things that I think are broken in our legal system. And in The Fix, I propose that states, including California, establish jury funds to adequately compensate jurors, and that large employers like Facebook, Google, Microsoft, Uber, Lyft, that large employers who regularly use our courts for free be required to continue to pay their employees who serve on juries. Almost all of these big companies do not do this. So I'm advocating for a state jury compensation fund, not just in California, but for all the states. Jurors matter. Okay, let's talk about judicial elections. Next slide. Judicial elections were first instituted in the late 1770s and early 1800s, when the territory of Vermont and the states of Georgia and Indiana used them to fill seats on their lower courts. In 1832, Mississippi became the first state to adopt elections for all of its judges. In the rest of the states, governors appointed judges to lifetime terms, quote, during good behavior, unquote. Now, as Anne pointed out, and some of you know, I was able to secure a seat on the Superior Court as a result of a countywide election in 1988, if you'll show the next slide. And this is the brochure that I utilized. And as you can see, I won with 62% of the vote. This was a countywide election, Santa Clara County, to fill an empty seat on the court. And the next slide, please. And here I am. This is a photo from the San Jose Mercury News, where I am high-fiving Judge Peter Stone, who was the presiding judge of the Superior Court. And this is at my swearing in. My mother is in between the two of us, and my daughter Star. And by the way, both of my daughters are now in their 40s, and little Star is standing behind me. And so in my book is a chapter called Judges for Sale, where I describe my election experience. And it's one that I would not wish on my worst enemy. So what happened? Read the book, because I detail exactly what happened. And why was it a bad experience? Well, first of all, it takes lots of money to run for a judgeship. I raised about $70,000. Today's dollars, that's about $150,000, mostly from lawyers, some of who then appeared in my court. So I think right there's a conflict. And that money, that $70,000 or $150,000, that's a pittance compared to today's judicial elections. So I'm going to read from the chapter, Judges for Sale. According to the Brennan Center for Justice, 1/3 of all elected justices, we're talking about the state courts now, currently sitting on the bench have run in at least one $1 million race. During the 2015-16 state Supreme Court election cycles, political action committees, social welfare organizations, and other non-party groups engaged in a record $27.8 million outside spending spree, making up an unprecedented 40% of overall Supreme Court election spending. Unsurprisingly, 56% of that money was contributed by lawyers, lobbyists, and corporate interests. And after the 2010 US Supreme Court decision in Citizens United versus FEC, allowed an unlimited flood of money into political campaigns, the floodgates to state judges' campaigns opened as well. But there's more. As the influence of money in judicial races grows, so does its impact on judicial decision-making. Again, from Judges for Sale. Kate Berry of the Brennan Center for Justice analyzed 15 years of television advertising data for state Supreme Court elections to gauge the ad's impact on judicial decision-making in criminal cases. Generally, the ads attacked judges for being soft on crime or praised them as tough on crime. 3 of Berry's key findings were that 1, the more frequently ads aired during an election, the less likely state Supreme Court justices were to rule in favor of criminal defendants. 2, closer to their re-elections, trial judges in Pennsylvania and Washington sentenced defendants convicted of serious felonies to longer sentences than normally imposed for those crimes. And 3, trial judges in Alabama imposed death sentences more often in election years, sometimes overriding life sentence verdicts handed down by juries. Judges are not politicians. Politicians make promises to voters to appeal to whatever it is that their constituencies want. Unlike politicians, judges are independent. The only promises that judges can ever make is to adhere to the rule of law, to adhere to legal principles, to adhere to constitutional precedent. Judges are held accountable by appellate courts who review the rulings and the decisions. They're held accountable by disciplinary commissions, and they're held accountable by properly run recall elections. It is my view that judicial elections should be replaced with independent nominating commissions that are bipartisan, appointed by diverse stakeholders, include non-lawyers, and have clear criteria for vetting candidates. The nominating process should be open, not secret like it is in California, and it should be transparent with publicly available data about the diversity of applicants and nominees. Now, until we rid ourselves of judicial elections, and by the way, I write more about that in the chapter, The Fix, but until we rid ourselves in California of judicial elections, we need to do a far better job of educating voters. I can't tell you how many times I've gotten these late night phone calls from neighbors asking me who they should vote for in judicial races. We need meaningful voter guides that include detailed profiles of the judicial candidates, including any of the results of evaluations by lawyers that are occasionally conducted by the courts. Okay, next slide. And now to the final subject of judicial independence. This is how I began the chapter in the book called J'accuse Judges Under Attack. There is frequently no warning or signal that a judge's decision is destined to blow up in her face. It could be her umpteenth sentencing decision in her umpteenth criminal case, but for whatever reason, one decision takes on a life of its own with disastrous consequences. And that's what happened to Santa Clara County Superior Court Judge Aaron Persky. In 2016, not just yet, well, that's right, leave that one up, that's fine. In 2016, Judge Persky presided over the criminal trial of a 19-year-old Stanford freshman who was charged with sexual assault of a 22-year-old woman, a college graduate. Both were at a fraternity party, and both were highly intoxicated. A jury convicted the student, who before he was even charged with a crime, had been expelled from Stanford. After Judge Persky sentenced the student to 6 months in jail, the recommended sentence by the probation department, all hell broke loose. He became the target of a recall campaign, you can see there on your screen, coordinated by a female Stanford law professor who has, to this day, never passed a bar exam, has never represented a client, has no experience in criminal law, and who was outraged that the judge had not sentenced the student to state prison. What the recall campaign deliberately ignored was that the punishment handed down by Judge Persky also included ordering this 19-year-old to register as a sex offender for the rest of his life. Before the recall was over, the name Persky would become infamous throughout the country and beyond. Next slide. So what you saw first was a mailer and a lawn sign. This is yet another mailer where a case that Judge Persky had sentenced this person, Robert Chain, it says to only 4 days in jail for felony child pornography. What it doesn't say is that this was what a plea bargain is, what the DA asked for, which was the 4-day sentence. You don't see that at all. Next one. And this is another mailer where they're trying to compare Aaron Persky to, as you can see, to Donald Trump. Okay, next slide. I became a spokesperson on Judge Persky's behalf in opposing the recall for a number of reasons, because the campaign lied about Aaron Persky's track record as a judge, because the sentence he imposed was within his discretion and was entirely lawful, because the judge was not legally permitted to speak about the case. And most importantly, I spoke out because the recall posed a threat to judicial independence. Next slide. Aaron Persky was recalled, supported by an infusion of, as you can see, millions of dollars, most of which did not come from within the county. Judicial independence. These two words have never been more misunderstood, distorted, and anathema to so many. Yet judicial independence is critical to maintaining our democracy. Next slide. Judicial independence was recognized in the Declaration of Independence when the Continental Congress penned its 27 grievances against King George III. And this particular grievance was, he has made judges dependent on his will alone for the tenure of their offices and amount and payment of their salaries. So what are we to do? How do we ensure that our state court judges maintain their independence? This is a serious issue, because when we lose our independent judiciary, we lose our already fragile democracy. So the answer that I propose in the chapter in my book called The Fix is to strictly limit judicial recalls to instances of judicial malfeasance or failure to perform duties of the office, or to judges who have been convicted of serious crimes. Next slide. That is the way it is done in Georgia and Montana. Recalls in these two states can never be based on a judge's lawful decision, no matter how controversial. And that's how it should be done in California. Next slide. The recall provision in the California Constitution is just one sentence. Recall is the power of electors to remove elective officers. So what this one sentence does is lump judges in with politicians. So next slide. If our legislators will not take the lead in amending the Constitution, that one sentence, then I think that we, the people, the voters, and the leadership in this could come from the League of Women Voters, should use your influence to make this happen. I've even drafted, as you can see, a suggested amendment. So it keeps the language in and adds the exception, meaning judges can be subject to recall, but never for making a lawful decision, no matter how controversial, but for these three reasons modeled on what is done in Georgia and Montana. Okay, before I conclude my remarks, I have to talk about my hair. Can we go to the next one? Okay, now, first of all, this is, if you look at my hair, it's really a journey through my time on the bench. So if you look at the bottom middle, that's 1982. I have the straightened hair, long flowing locks. Then if you look right next to it, my hair is shorter, got little bits of gray in there. It's still straightened. That was 1989, 88. And then I have it in little dreadlocks. And then as you go across really short, then I have it in a box. So I show you these. I wore my hair in these various hairstyles. Why? Because I could. Because Black hair is such that we can wear our hair in these various ways. But I also wore my hair these ways to send a message that, yes, judges can look like this. I used, as well as my being a woman, as well as being Black, I used my hair to bust stereotypes. And I raise this now because it's interesting to note that in 2020, Californians enacted the Crown Act. And why is that? The act was to ensure that no one can be discriminated against in the workplace on the basis of how you wear your hair. And that law was in response to rampant workplace discrimination against Black women who chose to wear natural hairstyles. Okay, finally, I want you to understand that there is much that is good about our legal system. The very principles that are the foundation of our system and our nation are the best in the world, that all are created equal and entitled to life, liberty, and the pursuit of happiness, that everyone has the right to a speedy trial. Everyone has the right to trial by jury. Everyone has the right against self-incrimination and the right to due process. The problem is in the implementation of these principles. The propertied white men who established these principles, many of whom owned people who looked like me, did not contemplate that these principles would apply to women, to poor people, and to people of color. The challenge for all of us, all of you in the league, is to ensure that these wonderful principles that underlie our legal system are applied equally and fairly to all. Final slide. So I leave you with this final passage of my book. Judging has been the most fulfilling of my various careers. For nearly 20 years, I wielded power over the lives of thousands of people. And for nearly 20 years, I did what I believed to be right. While it is up to the next generation of voters, politicians, activists, lawyers, law professors, legal professionals, and judges to continue to clear the path to a more perfect union, I refuse to give up on our legal system, and I will never give up on our judiciary, and hopefully neither will you. Thank you.
Thank you so much, LaDoris. I really, really appreciate it. It was great. And I have to urge everybody, after hearing this, we all have to read the book. It sounds fantastic, honestly. There were some questions in the chat, and one of them had to do, let me say it completely. How do you think the League can get involved in pursuing the idea of an independent nominating commission for electing judges? And I think what your discussion on that issue is really important.
Yeah, let me just bring up one thing, that in California, we have something called the Jenny Commission, and it's the Judicial Nominations and Evaluations Commission. And people who want to be judges, eventually, if they don't run for the seat, and I really would like us to abolish judicial elections, but if they don't run, then they apply, like I did when I was first appointed in 1982. This Jenny Commission meets in secret. So you don't know what they're doing, none of us do. And we're asked to, those of us in the legal profession, to send in evaluations of the person, but we never know what has happened. And when that commission ends up vetting names, saying these people, they send names to the governor. Now, the governor, however, does not have to appoint any of them. The governor can go rogue and appoint whoever the governor wants. That needs to stop. We need, if we keep it called a Jenny Commission, we need to open it up. I believe people need to know what's going on and being able to know who is being vetted. And once those names come out of the commission, whoever the governor is should be obligated to choose from those candidates who have been vetted and those names sent up to the governor.
Thank you. As a former chair of the commission that you just mentioned, I absolutely agree with you, although it can't be totally open. So there's some other questions here about how would you feel about term limits for the Supreme Court justices?
Are we talking, we must be talking US Supreme Court, because there are term limits for state Supreme Court justices. They can't be, I'm talking about state Supreme Court justices, when their terms are up, and generally they're 12-year terms, when their terms are up, no one can run for the seat. Only the governor can appoint. But the issue is, should they be retained? So there are retention elections, and I'm advocating to getting rid of those as well. So if you're talking about term limits for the US Supreme Court, yes, I believe there should be. I do not believe there should be lifetime appointments to the US Supreme Court.
The next question for you is, this is something of great interest to me too, whether there were consequences to you for your support of Judge Persky.
So I would love to actually do another presentation to the League just about the recall, because no one knows the inside story. And it was a nightmare. Now, it was truly a nightmare for Aaron Persky and for the Stanford student, for Brock Turner. It was a nightmare. Their lives are ruined. Anytime their names are Googled, you're going to get all this horrible stuff. That's horrible. But for those of us who spoke out, and I guess I was the leading voice in the opposition, it was a nightmare. So at some point, invite me back at some point. And I'd like to, and I have actually images I would like to show you, in addition to what you have seen, stuff that you would not believe that happened, including vandalism of my car, my lawn signs, opposing the recall being vandalized, and other kinds of things, threats. And that's because why? We live in the age of social media where the cowards can anonymously threaten and come after people. I did not let that deter me, but I was stunned by the reactions that I got. But I will tell you, fortunately in North County, and we're talking Palo Alto, let's say down to Sunnyvale, more than 60% of the voters voted against the recall. It was really the San Jose where the majority voted to recall Aaron Persky.
There's another question in the chat about your views on whether district attorneys should be elected.
District attorneys. If they're not elected, they would be appointed by the Board of Supervisors. Let's just talk about Santa Clara County, because the public defender is appointed by the Board of Supervisors. It's certainly something I'd like to think about, because right now we have an election going on in Santa Clara County. 3 people are running for the seat. And I'm telling you, folks, it's all about money. It's about who can raise the most money here to get the word out. So I think it's something for us to think about. And if it works, if you think, and so far, I haven't been disappointed with the public defenders that have been appointed by the Board of Supervisors, it might be something we want to look at. Although I can hear people saying, oh, wait a minute, voters, we should be allowed to decide who is the top prosecutor in the county. And I guess my response to that is, well, why is the top prosecutor any different from the top public defender? Why is one appointed and the other has to run for election? I don't know if the DA races are embodied in the California Constitution, and I don't know if they are specifically reference in something that had in the county's charter. I don't know. So that would have to be looked at. But I think it's certainly something we need to discuss.
Another question besides that one is that whether you think that the proposal about judges and not being recalled unless there is some other standard that is a more extreme standard, which I think is a really good idea. And personally, and the question is, should that be applied just to recalls in general? Because of the sort of expansion of people's desire to recall people at all levels of, whether it be boards, school boards, or the governor.
I mean, again, something worth thinking about. I know right now I'm concerned about the threat to an independent judiciary, and maybe I didn't make it clear enough. So once a study was just done, and again, if we ever do a Persky meeting, I can tell you more, but I can tell you generally, a study was done in 2020 in 6 counties in California to see the impact of the recall of Aaron Persky, not the actual recall, but just announcing that there would be a recall. The study showed that the judicial decision-making was dramatically impacted to the detriment of defendants just by announcing the recall. Excuse me. So, for example, one finding was that judges in these 6 counties imposed 150 years more time behind bars after the recall was announced. And generally, those defendants on whom that additional time was imposed, because these judges wanted to show everyone they're tough on crime, were people of color and poor people. Mm-hmm. So we know, and that's not an independent judiciary, when the decisions are influenced by what judges think might happen to them, if they follow the law and use their discretion, but follow the law. So there's that one. Now, with regard to school boards, and of course, we know there's a recall attempt of the DA in San Francisco. So again, it's worthy of discussion. I have not spent a lot of time thinking that all recalls should always be patterned on there must be a specific reason where someone has violated or done something wrong. That's not the history of recalls in America, by the way. The first of which was in Idaho, was really people were discontent with the railroad barons who were just kind of running everything. And the people decided, hey, we're going to speak up and we're going to get these people out, because not so much that they were committing crimes, but they were doing things only in their interests and not looking out for the people. Again, it's worthy of discussion, but what I'd like to see happen right now, because I think this is doable in our lifetimes, is to amend the California Constitution, which has been amended more than 200 times, to add the language regarding judicial recalls.
Okay. It does not look like there are any other questions in the chat. Is there anybody else that would like to ask the judge a question?
And I'll just add that my book is, right now, it's half price on Amazon if you do the Amazon thing. I'm a supporter of independent bookstores, and the book's at Books Inc. and Barnes and Nobles and wherever. So thank you. Thank you for thinking. I hope you will think about these issues. And I can't think of a better institution than the League to look at the fixes I'm recommending: juror compensation, recalls, judicial elections. And I have more in there. There are many more that we are not talking about today. And maybe we can come back and have more discussions at some point.
Anne, I do see one hand raised. Yulin. Yulin,
okay.
You have a question? You're muted right now.
Yes, I wrote my question on screen, but it was not answered. I guess it was probably because it was at the end. So anyway, my question is, what are the top reasons for the problems in implementation from your perspective? I think that you raised a very good question. I agree with you, spot on the issues. So if you could help us understand from that way, we can all work together, try our best to address these issues in implementation. Thank you.
And thank you for the question. It's just gets the key to everything. So why is there the problem with implementation? Part of this, and perhaps the main part, is the systemic racism, systemic sexism that has pervaded this country since the time these principles were enacted. So what we have is to remedy this, we need more diverse representation in all of these institutions. When people see people who look like themselves, when they walk into a courtroom, then they believe they have a stake in the system, which means they have respect for the system because there are decision makers, there are lawyers who look like them. And I say why that's important. In the first chapter in my book is called Bitten by the Judge Bug. I write about something that happened to me that brought home the importance of having all of us represented in the system to make the system work. So just very briefly, because I'm not going to tell you how it all ended, but I ended up, I was at Stanford. I was the assistant dean at the law school, and I volunteered for a day to be a judge pro tem, because there was a program in Santa Clara County that said lawyers could actually serve for a day as a judge and hear a small claims case. Small claims are cases where there are no lawyers. It's like Judge Judy on TV, and people are suing each other over not big amounts of money. So I was asked, would you come down and hear a case? So I presided over a case involving, and just one case, and it was two women, one suing the other, and they were both Black women. So I walk in and I'm like, this is a Black lady courtroom. What is this? They're looking at me, I'm looking at them. The issue was about hair. So one was suing the other about hair. One had done the other's hair, had done some cornrows, and I listened to them. As I write in the book, examine the evidence, meaning I asked the one who said she got a bad cornrow job to come up to the bench so I could look at it, examine it. I knew what to ask, and then I made a decision. And you can read the book to see what I did. But as I was driving home, I thought, one, I love doing this. I love making decisions where people can't work things out themselves. But even more, I thought, there were no, at the time, judges of color on the bench, and certainly no Black judges, and certainly no Black women judges. And I thought, if a white male judge had gotten this case, he wouldn't have known what to ask. He wouldn't have known what they were even talking about, which brings it home why it's so important that we have a breadth of experience and representation in all of these institutions, and specifically in the legal system. So I don't know if that answers your question, but we have to work hard to make sure there's a pipeline of women, of people of color who have access to these positions. There has never been an Asian American on the US Supreme Court. Well, until that happens, it is not representative of America. So these are the kinds of things, why these kinds of isms still pervade, why the implementation is still not where it should be. However, as I note in my book, I am ever hopeful. Progress is measured not by how far we have come, but how far we have yet to go. And we have come a long way from my great-grandmother and great-great maternal grandmothers being the enslaved to today, and a time when I could sit on the bench. Imagine if they were still here and seeing this. So we have a way to go, but what we must do is what I say to everyone: be an upstander. Don't be a bystander. And I think everyone in the League of Women Voters, talking specifically of West Valley, you all are upstanders. You're looking at what needs to be done, and you're finding ways to make things better, to make sure our democracy holds, and to make sure that we get people voting. You are upstanders. So I'll leave you just with this. My mantras. One is kindness. Just be kind. Imagine a world we have where everyone was kind. And second is this: activism is my rent for living on this planet. Mm-hmm. So my hope is you're active. Every one of you are paying your rent every single day. And I hope we can expand it and encourage everyone every single day. Do something that says, I'm paying my rent for living on this planet.
Wow. Thank you.
You're welcome.
Let me just say, there's a lot of people in the chat who have said that they would love to hear you talk about the Persky situation, as would I. So we hopefully can get together.
We can do that. We'll figure that out
again. And I have to say, I really appreciate you having spent the time. And I don't know if anybody has any more questions. I am in Mexico and I have to meet with the governor of the state.
Yay.
So
and you're the one that invited me. You are the one that invited me. So thank you so much. And I thank you, Barbara, and I thank all the folks, Sophia, everyone who worked to make this possible. So thank you for all the good work. Thank you for being the activist. Thank you all. And particularly you, Anne, for paying your rent every single day.
Thank you.
Wow, thank
all right, you all. Take care.
Thank you much. Thank you.
Bye.
Thank you, everyone, for truly enjoyed the presentation, especially the encouragement for the minority or who doesn't have a role in the system, including my daughter, who is very passionate about political science. I hope that we can learn some speech like this for the young generations.
Yes, yes.
Okay, so we are right on time, which is great. Yes. So before we finish the meeting, I'd like to remind everyone, this weekend, please, if you haven't done so, please fill your ballot and cast your vote. The primary election is June 7th. Okay, then without further ado, I'd like to announce the meeting is adjourned, and thank you everyone for attending the meeting. Wonderful gathering this morning. Thank you.
Thank you, Sophia. Great job.
Thank you.
Yeah.